Hello everyone, this is Amir Said and you're listening to the Viva Visa podcast by Adhami Law Group. In this episode, due to the emails we got through the last few days about confidentiality and how our law firm deals with your cases, we figured out that the best way to answer your questions would be through case studies concerning the client's confidentiality. So, the cases that Kusha will discuss are real and, of course, not easy to talk about in a media like a podcast. But because of the questions we got, we need to be more explicit about the situations and circumstances. So please stay with us and thanks for listening, and let's begin. Hey Kusha.
Good morning. Thank you for having me.
Kusha, would you describe a little bit about the confidentiality of the SIJS cases, why they are confidential and why they have to be confidential?
Oh my God. I mean, that's a great question. Okay. Let me just start by laying out confidentiality and the definition of confidentiality and where it applies. So starting by laying out between a client and the attorney, there is always a provision that covers attorney-client confidentiality. This means that communication that is done between the attorney and client are, for the most part, are kept as confidential. In regards to SIJS cases, we are dealing with one more layer of confidentiality because we are dealing with juvenile cases. These are minor cases. Now, if I could break it down in two different steps or two different areas, USCIS, I think they do a pretty good job in keeping this type of cases confidential because number one, they're juvenile cases, they're minor cases, and number two, these are victim-based cases. You know, these are children who were neglected, abused, and or abandoned by their parents or significant others or whatever. So USCIS takes a pretty good precaution in keeping this type of information confidential. So there are sometimes like you cannot make certain inquiries regarding the case, and the addresses need to be changed with certain departments. So they do a pretty good job on keeping the cases confidential. On the state court level, the predicate order, this is when we do in the first step, first stage, as I explained in our previous podcast. State courts also do a pretty good job in keeping this type of cases confidential. So, for example, in family law, when we do the petition to establish paternity and also SIJS findings, the cases are, you get a case number for every case, and you cannot have any sort of access to it online because they're for minors and they're confidential. There are different type of layers that are set to protect the minors, but I'll go a little more in detail and talking about this type of cases as well.
Sure, but I think it's at some point it's the cases are engaged with some, as mentioned, criminals and something like that, right?
What do you mean?
For example, if the guy is neglected by parents and the parents, one of them is abusive one, and then that case is a little bit complicated. It's just not about the kid; it's about abusing someone. So that kid wants to get away from that parent, that partners.
Right.
So it's not easy, like an easy case that we want to handle that. That's why maybe it's a little bit confidential. The question that I have is that when the clients come to your office, how you deal with these type of information, and how you.
I believe your question is, how do we manage to keep this type of information confidential?
Yes, that one.
Right.
But the second one is that level of the emotion that the guy has over there, how you engage, because it's not easy that I come to your office and say, okay, I have this problem. Usually there's a story. Maybe it takes maybe some session that you talk to them to understand what is all behind the scene.
Right. Okay, I can break it down. Just to rephrase your question, how do our firm or our staff deal with this type of cases and to keeping the client's case confidential? Okay, so starting from the first part of your question, our staff are very well trained in dealing with minor and confidential cases. I need to rephrase that these type of cases are very sensitive. You're dealing with minors, or even if the minor is not giving us the declaration, it's the parents who is usually giving us the story. And in both events, you are dealing with clients who have had traumatizing experience. So talking about this type of events and experiences can re-traumatize our client or the child. So we depend. Each case and each individual is different. But I've done too many of these cases, and
I'm sure.
Way too many of them. and our staff are very well trained in dealing with clients. So, for example, if we're doing a declaration with a client, and the facts involved in the case are very graphic, we usually either have the client just come for smaller sessions, so we don't do the whole thing in one day. We break it down, or we give the clients a lot of break time so that they can
feel a bit safe and secure. And then
exactly, we do that extremely well. Our clients feel very safe and secure at our office, so they can tell us everything. And that way, the more we know about the facts, the more we can do our job as lawyers to push for the rights of our clients. So the more facts we know, the better we can present the story to the judge, so they can understand the experiences that the child has experienced. So that's one way to deal with these cases. In terms of your second part of your question, dealing with confidentiality, I don't know, we had never had an incident where there was a disclosure of confidential information without the client's information or within the bounds of law. So we are very, 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 and I'm going to say very 3 more times, very, very, very cautious about disclosing any confidential information. Now, something that this actually brings to my mind is, so for example, this is a very typical situation, and I know Amir, you have a different question, but I want to talk about this. This is very important.
Right, it's okay.
I really want to talk about this. So we have situations where, for example, mom comes to our office with his son, and son is either 17 years old, 18, 15, whatever it is. And mom retains our services for a SIJS case for the son. In this case, for example, mom is 17 years old. Okay. And we move forward with the case. And at the beginning of our representation, I tell mom that, this is son's case. You're paying our firm, but this is son's case. So that means you may disagree with certain methods of my approach, but any sort of recommendation mom makes, I will take that into consideration, and I will not even do it if it's contrary to the interests of my client, because in that situation, the child is my client. So mom is paying me or our firm, but the client is the child in this case. I mean, depending on the contracts and everything. But usually my job, I've had situations where, mom or someone who is paying for the legal fees have said, oh yeah, you got to do this. And I'm like, you know what? Maybe not.
Right.
Maybe not, because my job is to, or maybe you should tell this to my son or my nephew or my grandson. I'm like, no, that it doesn't work that way. Our job is to, what's the word? Let me see. I did have enough coffee, but my brain is to
protect, maybe.
No, is to push forward the rights of our clients. Okay,
right.
That's so in terms of answering your question, we are very well experienced in dealing with our clients who have traumatized experience. And then we take excessive amount of care in keeping clients' case confidential.
Since it is important for the court that the case and the story must be right, true, and based on the facts. So sometimes people, maybe they don't want to open up, very open to talk about what happened to them, right? Maybe they come up with some stories and stuff like that. So your job is actually to find out what was the real scenario behind this scene and what was all about, and then put it in a way that can convince the court that this client is eligible to get that type of visa, right?
The relief. The type of SIJS findings.
Right.
The visa would be with USCIS.
Right.
So you mean like the first stage, yes?
Right, the first stage. The question that they have, what about the court hearing? Let us know about the measures taken to keep confidentiality.
Oh my God, that's a fantastic question, Amir. Okay, so it's extremely delicate because you have a client who has come to your office and has disclosed certain information that have never been disclosed to anyone before. Okay, now not only you're dealing with an anxious client who has provided this information to you, now the client has to appear before the judge and in a court, in an open hearing, and then may have to even talk about this stuff.
Right.
So there is a great solution for it. So SIJS cases at the state court level are confidential to its level of max that it is. Usually judges do not go in detail talking about the events that happen. If they do, we ask the court to conduct a confidential hearing, which means everyone in the courtroom has to leave. Because,
except judge.
Well, of course, yes. So of course, yeah. So it's going to be the judge, my client, and sometimes even parents are kept outside, depending
Really?
on, yes. Depending on who is the petitioner on the cases. So excessive measures are taken to protect the confidential information of minors. And sometimes, so for certain cases, like if mom was raped, and the child was born as a result, and the child does not know the facts of the case or the incidents that happened, we don't want to traumatize the child by letting them know about the information. So in this type of cases, usually the childs are kept outside the courtroom. If the judge decides to go in detail of the factual allegations of the case and talk about it. So closed hearings. I had a case where I had to not even just like my first initial reaction was, as soon as the hearing started, I asked to have a meeting in the judge's chamber so I can talk about, the case was pretty graphic, pretty
really?
difficult. Yes. So
Maybe we have to cover it for next episode.
I think we should.
Yeah,
I think we should.
right.
Of course, I'm not going to discuss.
Yes.
Confidentiality,
but it's good.
It can. I would like our listeners to know that they're not going to go out in the open court and have all this stuff that happened to them in open court where everyone can hear it. So that's not going to happen. And our office, and I am actually very sensitive to that area of these cases. So, close cases, sometimes, meetings in chamber, cases are very, very kept confidential because they are juvenile cases, and these cases are for minors under the age of 18 for the purpose of state definition. So I do believe that family law courts and guardianship courts do a pretty good job at keeping this type of cases confidential and their information confidential.
And for example, anything happen to the case, even after closing the case, everything will be confidential, right?
Okay, so for example, if you have a case in guardianship court, probate, usually if there are any notes that are left on the case following the hearing, the notes are cleared. So no one can access those information on the case unless the client or whoever that had was given authorized access to this type of cases. And for like family law cases, I think they even take a stronger measure to protect this type of cases. So when you're issued a case number, even you cannot even look up the case number online because it shows as if it doesn't exist, which I really like that. Yeah, it's pretty good.
Actually, it's not available on
No,
internet.
it's not public information.
Wow,
because
cool.
like, for example, if you decide to sue me for whatever reason, that case becomes confidential. So if you, like, for example, sue me for a car accident or a defamation or whatever, you put the case number in there, you can see it. It's public information. But these type of cases are not public information because they they involve cases for minors, and their information are kept confidential.
Good, great. If you want to leave us with one specific tip about the confidentiality, what would that be? Because we are getting close to the last moment of this episode.
The one tip that I can provide to our listeners is that whatever you tell us at our office is going to stay in that office and it's not going to go anywhere. And the more honest they are with providing the factuals of the case, the easier it is for us to help them and get them the SIJS predicate order and later on a green card.
Perfect. Okay, Kusha. Thanks for joining us, and I want to say thank you to our listeners. I hope you enjoyed and learned from today's episode. Make sure to check out the show notes with the description for access to our website, and also make sure to share this episode with your friends and subscribe wherever you listen to your podcast. We really appreciate hearing feedback from you, so please share a review for this episode or check out our website and ask your questions. We are located in 21031 Ventura Boulevard, suite number 760, Woodland Hills, California 91364. You can also call us at 213-204-6500. Until the next episode, take care and bye.